Hi, welcome to Blockchain Law TV. I'm your host, Anki Kwan, and in this episode, I wanted to talk about the SEC's recent notification to Kik that they were going to recommend an enforcement action against them. Recently, I talked about how the SEC is going after every player in the crypto industry, regardless of whether they've acted in good faith. In November, they went after two companies that raised money with ICOs where there weren't any indications of fraud, and those companies simply settled with the SEC. Kik, on the other hand, they are doing something different. They're actually fighting back, and in their public materials and statements, they say that they are going to fight the SEC. When the SEC notified Kik that they were going to recommend an enforcement action against them, they invited them to respond to their notification with something called a well submission. So Kik responded to the SEC and argued that the SEC shouldn't pursue an enforcement action against them, and they listed 3 reasons why they shouldn't pursue this action against them. Their first argument is that KIN, the token that they sold during their token sale, is a currency and not a security, and under the securities laws, a currency is exempt from the definition of a security. Their second argument is that the KIN token isn't a security under the Howey test. And finally, they argue that even if they were selling securities in violation of the law, the SEC shouldn't pursue any actions against them because they complied with the law in good faith, and an enforcement action would be detrimental to purchasers that purchase the KIN tokens. So what happened in the KIN token sale? Kik, which is the company that created the KIN token, decided to raise money by selling their tokens to accredited investors using a SAFT, and then when the KIN token was fully functional within the Kik ecosystem, then they would sell those tokens to non-accredited investors. In other words, at that point, they would open the sale to the public and allow every person that wanted to purchase the token to purchase the KIN tokens. Back in the day when they did their token sale in 2017, the thought was that if you sold tokens to investors using a SAFT, and then you sold tokens to investors later on through a token sale, you would be compliant with the law. During the time that the tokens are sold in the SAFT, it wasn't functional, so accredited investors would take on the initial risk. And once the tokens were functional, the thought was that purchasers would purchase these tokens for use within the ecosystem rather than purchase it for investment purposes. They would buy these tokens because they wanted to consume these tokens and not because they wanted to speculate or make a return on their investment. So that's what happened during the KIN token sale. They did their token sale shortly after the DAO report. If you've ever watched one of my past videos, or if you follow the SEC's proceedings against crypto companies, then you know that the DAO report is the first time that the SEC has ever spoken out about ICOs or token sales. And in that report, they simply investigated whether the DAO token sale was an offer and sale of securities And they also tried to determine whether exchanges were also subject to the securities laws. And in that proceeding, they determined that some tokens and some sales of tokens are subject to the federal securities laws, and exchanges that sold tokens were also subject to the securities laws. But at the time, they decided not to pursue any actions against the participants in the DAO token sale. It was just a way for the SEC to warn the industry that the securities laws apply to them. As I mentioned in a previous video, in November, it seemed like the SEC was really ramping up its enforcement action, and they began going after companies that did token sales after the DAO proceeding. And this was regardless of whether they tried to follow the law and regardless of whether they had committed fraud. Kin is one of the companies that the SEC decided to go after. But unlike the other companies that settled with the SEC, Kik raised $95 million, and it has a lot of resources at its disposal. So Kik decided to fight back against the SEC. And in its submission, it argued to the SEC that, first of all, our token is a currency, and you said that currencies like Bitcoin and Ether aren't securities. Therefore, we're also not a security, and the securities laws don't apply to us. Not only are Ether and Bitcoin considered currencies, but a currency is exempted from the definition of a security under the US securities laws. That means that if something is a currency, the SEC has no power to regulate that currency. It's outside of the SEC's jurisdiction. The second argument that Kin made is that Kin tokens are not securities under the Howey test. The Howey test is the test that the SEC applied in the DAO proceeding to find out whether DAO tokens are offers and sales of securities. Under the Howey test, a token is an investment contract and therefore a security if it is an investment of money in a common enterprise where the buyer reasonably expects profits from the efforts of others. In other words, if someone buys your tokens and expects you to use your entrepreneurial or managerial efforts to make them a profit, then it's likely that those tokens or the sales of those tokens are securities. The SEC applied this test to every company that sold tokens to raise money. If the tokens passed the Howey test, meaning that they met all prongs of the Howey test, then they were considered a security. And if you are offering and selling a security in the United States, then you're required to comply with US securities laws. That means either registering with the SEC or finding an exemption from registration. Kik didn't believe that their tokens or the sale of their tokens were securities, so at least not when they sold it to the public. When they sold the SAFT, they believed that the SAFT was a security and they did find an exemption. But when they sold their tokens to the public, they didn't believe that the securities laws applied to them, and specifically in their submission, they're arguing that the Howey test doesn't apply to them. Specifically, we'll go through each prong and determine what Kik said about each prong of the Howey test. As to the first prong of the Howey test, there is a security if there's an investment of money in a common enterprise. The investment of money prong doesn't have to be addressed because the purchasers gave Kik money in exchange for tokens. So in that sense, there's an investment of money. But the second prong, which requires that there is a common enterprise, the SEC never really paid this prong much attention. In the Dow proceeding and in all cases after the Dow, the SEC just assumed that there was a common enterprise. In Howey, which gave rise to the Howey test, there was a common enterprise because purchasers purchased plots of land and they also entered into contracts with the Howey company to service the land and to work the land so that they would derive profits from their land purchases. So by virtue of that, it was determined that there was a common enterprise in the Howey case. But the SEC never really went into much detail about whether a common enterprise existed in the Dow proceeding or in any of the other cases after it where the SEC claimed that these companies doing ICOs had violated the law by selling investment contracts without registering or finding an exemption that didn't require registration. Kik argues that there isn't a common enterprise because the only thing that the purchasers expected them to do was to give them the tokens. As to the second prong, whether the buyers expected Kik to make them money or whether the buyers expected a profit from buying Kin, Kik argued that the buyers couldn't have reasonably expected to make a profit based on what Kik had advertised. Unlike the other issuers that sold tokens, Kik didn't emphasize that the purchasers would make a return on their investment. In the first case where the SEC went after a company selling tokens, a company called Munchie offered and sold tokens to people who were interested in investing in those tokens, and they also emphasized the efforts they would use to make Munchie tokens more valuable. In Kik's case, Kik never said anything about what they would do to make Kik more valuable. Rather, they emphasized the use cases for Kin. They emphasized the use cases for Kin and how Kin could be used in Kik's ecosystem to buy goods and to earn tokens. Finally, as to the final prong of the Howey test, whether profits were derived from the managerial or entrepreneurial efforts of others, Kik argued that any profits that could have been derived from the sale of Kin tokens wouldn't have been from the managerial or entrepreneurial efforts of Kik. To that end, Kik admits that they spent significant efforts creating the Kin ecosystem and will continue to do so. It also emphasized that Ethereum was considered not a security by Director William Hinman of the SEC, even though the Ethereum Foundation expended significant efforts in creating the Ethereum ecosystem and continues to do so. In addition, Kik emphasized that any increase in value is because of the other participants in the Kin ecosystem, and that the ecosystem and the Kin token itself won't be valuable unless other people also contribute to the ecosystem. And Kik is only one of the many players in the ecosystem that would make the ecosystem and Kin valuable. Finally, they argue that Kin is like a commodity, and in cases where commodities were sold to buyers and then later increased in value, those cases commodities were not considered securities because the rise in price of the commodity was based on market forces rather than any managerial efforts of the seller. Based on those arguments, Kik argued that Kin is not a security as defined by the investment contract test under Howey. Finally, Kik argues that the SEC shouldn't take action against them because Kik complied with the law as they understood the law at the time of the sale. They emphasized that they hired accountants and lawyers, all of whom determined that Kin were not securities, and the offer and sale of Kin likewise were not securities. For example, their auditor told them that Kin was a commodity and they had Kik pay tax on the sales of the Kin tokens, and likewise their lawyers also advised them that the securities laws didn't apply to them. At the time that Kin was sold, the only guide that Kik had to go on was the Dow report. The Dow report didn't say that all ICO tokens are securities. It simply said that some ICO tokens may be securities. The Dow report only analyzed one type of token, which was the Dow token. The Dow token was sold to purchasers because they wanted to invest in certain projects, and they could vote on which projects to invest in because they had purchased these Dow tokens. In addition, these tokens gave them the right to receive dividends, and because of these characteristics, the Dow tokens were securities. Unlike the Dow token, the Kin token is different. The Kin token was used to buy and sell goods and to be used in the Kin ecosystem. Because of this, Kik differentiated itself from the issuers of the Dow tokens because the characteristics of the Kin tokens were not like the characteristics of the Dow tokens. Not only that, but at the time, no issuer of tokens had registered with the SEC, which suggested that everyone thought that tokens were not subject to the securities laws. And Kik's argument is that they could only act on what they knew about the securities laws and how it applied to Kin tokens at the time that they had offered and sold their tokens, and they had complied in good faith, including the fact that they had barred people from buying their tokens in places where they didn't know whether they could legally sell tokens, such as China and Canada, and had they known that the US didn't allow sales of such tokens because they had violated the securities laws, Kik would have barred purchasers in the United States from purchasing these tokens. Finally, they also argued that punishing Kik is not only unfair to Kik because it had acted in good faith and it had acted per their understanding of the law at the time that they sold these tokens. So it would be unfair to them, and not only that, but it would also be unfair to the purchasers because they would likely get delisted from exchanges, meaning that purchasers can no longer use kin in the kin ecosystem, and developers that earn kin would no longer be able to sell their kin for US dollars if it was delisted from the system. And not only that, but future purchasers also can't use kin to make purchases or to participate in the kin ecosystem. Based on these arguments, Kik wants to convince the SEC not to take enforcement action against them and not to file an enforcement proceeding against them. I hope that you found this video helpful and it helps you understand what's happening in the case of Kik versus the SEC. As of today, there are no indications that the SEC has filed a proceeding against Kik, but you should also keep in mind that the government has been shut down for the past month, so the SEC is just starting to get back to work. So we have to wait and see if the SEC will file an enforcement action against Kik. If the SEC does file an enforcement action against Kik and Kik litigates the enforcement action, then it will provide guidance to companies that are looking to raise money with tokens about the state of the securities laws, because a court will provide us guidance about how exactly the securities laws apply to the offer and sale of tokens. If you found this video helpful, please share with someone else who can use this information. Thank you for tuning in, and I hope you have a fantastic day. Bye!